The 5th District Court of Appeals is now in session. Justice Peterson presiding.
Good morning, everybody. We're here on case number 0519011174, CV, Michael W. Griggs versus Victor L. Cohen. Are both sides present and ready?
Yes, sir.
Yes, Your Honor.
Okay, all right. I don't know if y'all, how often y'all have argued in front of the Fifth Court before. On one of your panel windows, there's a timer, 20 minutes for the appellant, 20 minutes for the appellee, and then 5 minutes rebuttal for the appellant. The light will be green until you have, I think, 3 minutes, and then yellow, and red means stop unless you're, finish your thought or respond to any questions from any of the members of the court. But then once it gets red, it's time to shut it down. Appellant, you may begin whenever you're prepared.
Thank you, Your Honor, and may it please the court. Good morning, everyone. My name is Eric Montrose. I represent Michael Griggs. He was the defendant in the trial court, and he's the appellant here. This case stems from a car accident that happened on February 11th, 2017, and the alleged injuries that Victor Cohen sustained in that accident. The case was tried on June 5th, 2019 in the 101st District Court in Dallas. The court entered judgment on the verdict, which awarded, among other elements, $10,000 and $600 for future medical expenses. Mr. Griggs had filed a motion for judgment notwithstanding the verdict and a motion for new trial combined in one pleading, and the trial court denied both, and so this appeal was filed. And this appeal is based on the both legal and factual insufficiency of the evidence to support the award of future medical expenses. And so for the legal sufficiency first, the controlling rule is the reasonable probability rule, which has been articulated by this court in Walmart Stores versus Crosby. And that rule is that a plaintiff must show the amount of the future medical expenses and show that there's a reasonable probability that such expenses will actually be incurred in the future. And stated differently, to sustain an award for future medical expenses, the plaintiff must present evidence to establish that in all reasonable probability, the future medical expenses will be required, and evidence of the reasonable cost of the future care. And so I would like to submit 3 points to the court to explain why that the evidence was legally insufficient to support the future medical expenses. The first is about Mr. Cohen's testimony at trial about his current pain. Point 2 is about Mr. Cohen's testimony of his chiropractor's referral for futures. And point 3 is about the discharge report that was admitted into evidence from the chiropractor's records. So to discuss point 1 first, which was Mr. Cohen's testimony about his current pain. The case law says that testimony, even about current pain at trial, does not support an award for future medical expenses. There was a similar case out of the Houston Court of Appeals called Rosenboom Machine and Tool versus Machala that I cited in the appellant's brief. The plaintiff there was awarded $10,000 in future medical expenses and tried to support that by saying that they testified about current pain at trial. And the Houston court said that that does not support an award of future medical expenses. To me, it's a common sense rationale. Just because you have some pain at trial doesn't mean you're necessarily going to go for more treatment in the future. And it doesn't establish that you probably will, and it also doesn't establish anything about the reasonable cost of the future care. So Mr. Cohen's testimony about current pain at trial does not support an award of future medical expenses. Point 2 was Mr. Cohen's testimony at trial about a chiropractic referral. What I'd like to talk about that testimony is he still has to meet the reasonable probability rule. And when he was testifying, he didn't say anything about how likely he was to go for this future treatment that he's sort of discussing what his chiropractor told him. In fact, he said the opposite. He said he doesn't have any plans to go for future treatment. And Mr. Cohen also never testified about what would be a reasonable charge for the care. He just threw out a few numbers, but he never discussed if it was reasonable to charge that for the future care or why. And indeed, he's not qualified to discuss reasonable future medical costs himself. So any testimony from Mr. Cohen about his chiropractor's referral for future care will not support this future medical expense award.
So is it your view, Mr. Montrose, that Mr. Cohen's entirely unable to provide any competent evidence on future medicals?
Well, I would say he's in the best position to tell us if he actually plans to go forward with the future treatment, because this is chiropractic care we're talking about. It's kind of therapeutic in nature. It's nothing that is.
Well, I thought you just said you lacked the qualification to give that kind of testimony.
Well, I think he lacks qualification to talk about the costs of it.
Oh, I'm sorry. Okay, thank you. I just wanted to clarify.
Okay. And my last point I wanted to talk about was the discharge report that was admitted into evidence as part of the chiropractor's records. And in the little narrative in the report, it does say he will likely continue to experience pain. But regarding that future treatment, it just says it could have to be addressed in the future. It also says future treatment may include. So words like could and may, I believe, just sort of talk about the possibility of future care. The discharge report never says that he will probably need future care. It just says that he will likely continue to experience pain. But like I was talking about earlier, current pain is not evidence of future medical expenses. Moreover, the discharge report from the chiropractor does give some estimates of the cost of these future procedures. But then right after that, it says, if Mr. Cohen is to have any sort of future procedures, the chiropractor must defer estimating the amount to the future provider of the procedures. So I think on its face, the discharge report is saying it's not giving a reasonable cost for the procedures.
How could a qualified expert say anything different than that? How could a qualified expert give you an exact forecast of future medical expenses?
Well, I don't think it could be an exact forecast, but from my reading of this discharge report, he's saying that he can't even give an estimation. Like, he gives the estimation and then says he can't give it. So to me, it makes more sense that that the person, discussing future treatment would at least say that they can give some sort of range.
Did he give a number that the jury wrote in on the jury charge?
He did, but right afterwards he says that he's not sure about that. So that's
but the standard isn't being sure, is it?
Well, no, but he's saying he has to defer an estimation to the future provider. So I think it's very inconsistent.
Well, I mean, we do the same thing when we're awarding, appellate attorney's fees. Nobody can absolutely predict what's going to happen in the future, and it would be irresponsible to try to do that, wouldn't it?
Right, I'd agree with that. But I just am confused by the fact that he gives an estimate and then later says he must defer the estimate. So that's what I take issue with that. And further, with the discharge report and all of the medical records that were admitted at trial, really, they went in under Texas Civil Practice and Remedies Code 18001, which is an evidentiary statute that is meant to prove up past medical records and past medical charges, which you could tell just by reading the statute. It talks about services provided and amounts charged in the past tense. I don't think 18001 was ever meant to prove up future medical care.
Was that raised below?
No, sir, it was not in the brief. And so with those three points, again, the testimony about future pain, the testimony about the referral, and the discharge report, I believe that none of those are competent evidence to support the future medical expense award, and so that there is legally insufficient evidence to support the award. If the court disagrees with that, I think that this is still a good example of a factually insufficient case to support future medicals. Aptly argued in their brief that we did not move for a new trial. That's not true. Like I was saying earlier, we moved for it combined with the motion for judgment notwithstanding the verdict, that was filed on July 22nd, 2019. It's page 81 through 84 of the clerk's record. And the reason I think that this is a good candidate for a factual insufficiency reversal is that the standard for factual insufficiency is that the evidence, even if it was legally sufficient, is so lacking as to make the result manifestly unjust or clearly wrong, are the phrases that I saw used in the case law. And again, I would point to Mr. Cohen's own testimony under oath, saying that he doesn't plan to go for future medical treatment. And even in his brief, he never denied that that's what he said under oath. So I think that it is manifestly unjust and clearly wrong to make my client have to pay for future treatment that Mr. Cohen, by his own admission, has no plans of getting. And so if the court thinks that there's legally sufficient evidence, I would submit that this evidence is factually insufficient to support the award of future medical care. And like I was saying earlier, I think Mr. Cohen is in the best position to tell us his plans for the future. And so with that, I will conclude unless there's any questions and save my time for rebuttal.
I do have some questions. Justice Rychek, did you have any? No. Okay, so couple questions. One, in looking through your brief, when you talk about the law generally, you talk about reasonable probability, both as to the fact that there will be future medical and as to the amount. But when you get down to the argument section of your brief, I'm not finding arguments saying that there's no evidence to support the amount, the 10,600. Where in your brief would I find argument challenging the evidentiary support for the amount?
Let me see. I'm actually not seeing it in my brief right now.
Okay. Now, the doctor said there's a probability that he will continue to suffer pain in the future. And Mr. Cohen testified that he would probably seek medical treatment if he felt pain in the future. Why is that not evidence of at least a probability that he would seek medical treatment in the future?
I think the way he answered that question shows that he was just kind of saying it was more possible. He was asked about plans. He says, no, not unless I start hurting again all over. He never explained why he's probably going to start randomly hurting again all over from this 3-year-old car wreck.
Yeah, but didn't the doctor say that? Can't we combine those two things to get to the point where it's more probable than not that he will seek medical help in the future?
Well, I don't think so, because the discharge report was dated from April 2017 and the trial wasn't until 2 years later. And he was still saying he still never even at trial, he didn't testify he was currently in pain. He said things like it comes and goes and at times. So I don't think that this is evidence that he's probably going to have pain flare up even further in the future past the trial.
Okay. All right. Those are my questions.
Anybody else? Justice Rychek?
No, I'm good.
Okay. Mr. Montrose, thank you very much. Mr. Bogus, let the timer get squared away there. Okay, Mr. Bogus, you may proceed whenever you're prepared.
Thank you, Your Honor. Well, good morning. My name is James Bogus, and I represent the appellee, Victor Cohen. In this case, there was evidence supporting the future medical treatment, and it was it meets the standard under the case law. It consisted of the evidence in the records from the chiropractor that treated Mr. Cohen, that he would need future treatment and how much it would likely cost, his estimate of that cost. under the case law, that would be sufficient. There is case law upholding future medical expenses, even without an estimate from provider. Most of the case law where the medical expenses were not, the future medical expenses were not upheld, were cases where there was no estimate of future expenses, and they hadn't treated in 4 years, and there wasn't a lot of testimony at trial from the plaintiff indicating that they would need any future care. So in this case, we do have ample evidence, and it seems like the appellant is taking the position that the statements under, I believe it was under cross-examination at trial by Mr. Cohen, that he had no current plans for treatment would negate that those estimates that were provided by his medical providers. And I don't think there's any precedent for that. I don't think there's any precedent for a statement from the plaintiff that he has no future plans for treatment would mean that he no longer has a basis for future medical expenses. And his complete statements, I'm sorry.
I was going to say, address the argument your colleague made right at the very end, that when you look at the time of the discharge report and the time of trial, and there hadn't been any perceived need for medical expenses during that time, that it then becomes, I think this is the argument he's making, that it then becomes unreasonable to infer that it would be required beyond trial.
Right. And what he testified to was that when he completed treatment, he no longer felt pain, but that the pain did come back.
But he didn't seek treatment in the interim.
He had not sought any treatment in the interim. That's correct. But that doesn't mean he would not seek it later on. And of course, at that point, he hadn't been awarded any money to do so. So this, with the judgment awarding him future medical expenses, he would now have that money that if he wanted to go and get future treatment, he could.
Well, let's back up a second there. Did he ever testify that he wanted to go see a doctor for additional treatments, but lacked the money to do so?
He did not. No, Your Honor.
All right.
No, he did not. But it seems if you look at the fact that there was, and by the way, the report from the doctor that included the estimate for future treatment was admitted none under 18001. That would have been where the charges were admitted, but it was under the business records exception to the hearsay rule. But there was no controverting expert. The only evidence that the jury heard from any experts at all was, there was no testimony from the treating doctor either. But what they did have was that report, which was duly admitted, which included those future expenses. And then they heard the statement from Mr. Cohen saying that he had no current plans for treatment, and yet they still felt that it was fair and reasonable to award those future medical expenses. So I believe the standard was met, and I don't believe there's any precedent, nor should there be precedent for saying that you can't get medical expenses if you say at trial, I don't have any plans to get future treatment as I sit here today. I believe that's all I have. I'll be happy to answer any questions. We ask that you affirm the verdict and the judgment.
Anyone have any questions?
No.
Okay. Well, Mr. Montrose, if you have any rebuttal, you have 5 minutes.
Yes, Your Honor. Okay. Just briefly, I would again point out that the discharge reports uses words like could and may, talking about the futures. Even under his testimony, I'm looking at the answers that Mr. Cohen gave, and he was talking about, he said no when he was first asked about plans for future treatment. And then they asked him again, and he said, no, not really, unless I start hurting all over again. I think that is more consistent with him just saying it's possible. And one of the briefs, or excuse me, one of the cases I cited did have language in there to the effect that the mere chance of needing future medical care is not sufficient to meet the necessary quantum of evidence. And so I don't think that there's evidence of a probability he'll need it going forward. And I asked the court to reverse this award for future medical expenses. And
Let's assume that he did just go to the doctor. He's feeling pain and decides to go to the doctor. Could the jury on this record reasonably infer that some dollar amount would be exchanged in going to see the doctor?
I think the answer to that question is yes. But I don't think that they could reasonably infer that he would go in the first place.
All right.
Any other questions? Okay. Well, thank you both very much. We appreciate your help in helping us come to the correct decision in this case, and the case is submitted.
Thank you.
Thank you. Are we excused?